Good afternoon, and welcome to this week's webinar presented by Beresford Booth. My name is Per Oscarson. I'm an attorney and a member of the business and real estate group here at the firm. And I'm going to be talking today on recording documents in real estate records. So the first thing is, what are we recording? What is recording? Recording of a document is a process of making various types of documents part of the public record so they can be visible to other folks. And although they're recorded in the real estate records, they may or may not directly affect title to the real estate. Now, you see here some examples: deeds, mortgages, deeds of trust, liens, and judgments will directly affect title. Because, for example, with a deed, you've got party A transferring title to the property to party B. That second set that you see there, community property agreement, power of attorney, marriage certificate, and military separation record, may not immediately affect real estate. For example, a community property agreement, although it might deal with real estate and probably does, it doesn't necessarily affect the title at the time that it's recorded. It merely puts it on the record, that on the real estate record, that there is such an agreement. And if there is real estate in that county, then it would be affected by that community property agreement. Another thing, power of attorney. Very often a power of attorney document grants the authority to the attorney in fact to deal with real estate. But at the time that the power of attorney document is recorded, there may not be any need for the attorney, in fact, to take any action concerning the real estate, so it doesn't affect the title. Again, similarly, a marriage certificate in and of itself would not affect title. It may be useful for some other purposes relating to title at some point in the future. It's not necessary for a document to be recorded in order to be effective as between the parties. So for example, a deed, party A could give party B a deed. It's good. You need to take that next step of recording it for some reasons we'll get into in just a few minutes. There are a couple of exceptions. The main exception that I think of as far as documents not being recorded but still being effective is if a power of attorney document is recorded, and the person granting that power then wants to revoke the power, it's only effective if the revocation document gets recorded in the same records where the power of attorney document was recorded. In Washington, I guess it's possible that a power of attorney document could get recorded in all 39 counties. And in order to revoke it, there's an argument that you'd have to file or record the revocation in all 39 counties. So where do you record? You record at the county level, but the county office that you record with differs, but only for one county in Washington. Usually you record with the county auditor, and that's true in every county except for King County. King County has separated the recorder's duties from the auditor's duties, and so there's a separate office called the recorder. But their functions are, as far as recording documents, are the same whether it's the auditor in other counties or the recorder in King County. Why do you record? You record, one reason is to give constructive notice to the world. And I say part of the world because the notice is to those people who might get an interest in real estate after the date of the document that is involved. There is no constructive notice to someone who may be have an interest in that real estate before this document is recorded. So for example, a lender situation, you've got a first mortgage. You then want to get a second mortgage. The second mortgage lender is going to want to know who's ahead of them in priority. So that second lender, they would have to take constructive notice of the first mortgage. But the fact that the second mortgage is being taken out doesn't affect the first mortgage lender. might affect their loan and the mortgage, because it may be prohibited to get a second mortgage without maybe getting consent of a lender. It's also constructive notice because as the person who is supposed to be entitled to the notice, you have to go look at the record. And you are deemed to have received the notice whether you check that record or not. So if you decide you're going to take action with a property owner, for example, and you decide, I'm just not going to bother checking the records, you do that at your own risk. Another thing in why we record is to give notice of the document and its provisions. The document itself can be viewed. In a lot of counties, it can be viewed online through the auditor or the recorder's website. Some counties in Washington do not have that capability because it can be expensive to scan all of those and organize them, and some counties just don't have the budget to do that. You can see the provisions of the documents in practically all cases. King County has an exception for deeds of trust. You can find that there is a deed of trust on a particular piece of property, but you won't be able to find an image of that document. Several years ago, I think it was the county council had decided there's too much personal information in a deed of trust, and we don't want that available online. If you have to go to the recorder's office to look at the deed of trust, you can do so, but you can't find it online. I'm a little surprised at that, and was at the time that they did it, because of the fact that there's not an awful lot of personal information, such as a social security number, for example. That would not be in there. But they've got the names of the borrower, the owner of the property. They've got the address of the property, and the deed of trust usually sets forth the dollar amount of the loan. Now, 10 years down the road, that document still shows that there's X number of dollars as the loan, but that may not be the outstanding balance. But be that as it may, King County has said you're not going to get to see the deed of trust. It also gives an indication to anyone who examines the record who has an interest in the property, whether as an owner or maybe they are a lender. You can find out potentially which lender has the interest that may have been assigned. That interest may have been assigned, and the new assignee may not show up. But at least you know that there's someone out there that has a mortgage against the property or a deed of trust. Maybe someone filed or recorded a lien against the property. For example, you had work done on your home, and the contractor didn't get paid. Maybe they file or record a lien against the property. Again, then you can find out who that contractor is, and maybe they got paid in full. If they did, they should have released the lien. And if they didn't, then you can find out, well, they should have, and get that taken care of, because you'll probably have to clean up the title at some point. Again, because you can see the provisions of the document, you can see what kind of rights the document may provide to parties to the document. That may or may not be important for the transaction that you might be involved in, or the reason that you're looking into the ownership of a particular piece of real estate. Again, this is protection for dealing with I call it the quote unquote owner of the real estate, because you may be dealing with someone who says, sure, I own this property, I'd love to sell it to you. Well, you look at the record, you find out they don't own the property. And this allows for checking to see who does have an interest in the property again. It's probably better to deal with a title company that will examine the title and tell you for certain who owns the property, because sometimes the record is not clear. For example, quitclaim deeds are often used to transfer interest. Well, a quitclaim deed only transfers the interest that the owner has, or the grantor of the quitclaim deed has. That grantor may not have any interest in that property whatsoever. For example, I could give a quitclaim deed on the property on which our offices are located. I don't have an interest in that property, but I certainly gave a quitclaim deed. I just didn't give you anything that was worth anything. Conveyance, that's where it gets very important. It's a transfer of an interest in property, whether it's title to the property, as you see, a mortgage or a deed of trust grants an interest in the property. It's not an ownership interest in the state of Washington, but it is an interest in the property. Wills, although typically not recorded, could be, but they don't, as at the time of recording, generally, assuming that the maker of the will is still alive, don't grant any interest in real estate. You see there a lease of real estate for less than 2 years, same situation. And again, a power of attorney that grants authority to convey real estate doesn't affect the real estate until that authority has been exercised. So why does it matter? It all goes back to this notice question. And it is important because there are some things where you as a property owner and someone, even a mortgage holder, for example, want to make sure that their interest is of record because they could lose out in priority. So I have two examples there, the buyers and lenders. For example, a buyer, person A owns the property and they sell it to person B and they give the person B a deed. For whatever reason, that deed does not get recorded. Person A is kind of unscrupulous and they decide a year later, I'm going to sell the property to person C. Well, person C checks and finds out, they check the records and they find out, oh, person A does own this property. I will buy it. Person C buys the property, gets a deed and records it. And now person B says, hey, wait a second, I have a deed. Well, if you notice the quoted language here at the very end, where it talks about whose conveyance is first duly recorded. In my example, person C is likely to win out over person B, even though person B bought the property a year before, because person C got their deed recorded before person B ever did. And that's true whether person B ever records it or if person B records it the day after person C. You could look at the two deeds. The dates of the deeds would be significantly different, but it's the recording date that matters. The same kind of thing would hold true for lenders. A typical lender wants to be in first position. They want to have the first mortgage or the first deed of trust. They'll check against the property. Person A grants a deed of trust. They take out a loan. They grant a deed of trust to lender, person B. B doesn't record their deed of trust. Person A then goes to another lender, whether the next day or a year later, and gets a loan, gets a deed of trust, and that person C records their deed of trust. Now person B decides they're going to record their deed of trust. Well, if B had been prompt in recording their deed of trust, they would be in first position in my example. But because they waited, person C has now moved into first position. Person B is now in second position. And most likely not too happy about that. So what are the requirements for recording? There are a number of them. There's the format, the size of the paper. For example, it can't be larger than 8.5 by 14 inches, legal size paper. There's a minimum size of type, 8-point font, for example. There are certain margin requirements. The first page, for example, has to have a top margin of 3 inches so that the recording information can be provided there once the document's recorded. There has to be 1 inch all the way around on the first page, other than the top 3 inches. And on all succeeding pages, it's at least a 1-inch margin. If there is written material that bleeds into the margin, the document could be rejected for recording, or if it's a minimal thing, for example, a notary seal, for example, part of it may extend into the margin. It may still get recorded, but that portion of the seal would not get recorded. Ink color. It has to be an ink that could be easily scanned by the county's scanning system to put it into the available for website view. So certain colors of ink probably will not work. Yellow is not likely to work too well. Blue and black are normally pretty good. The document has to be legible, and that should be fairly easy for the more recent documents. Older documents, and then when I say older, I'm talking maybe 100 years ago, where they were all handwritten documents, may not be legible, or they may be very legible, but for some reason the copy quality is not the best. There are requirements for the content of documents to be recorded. The names of the granting party and the grantee party, which will vary depending upon the type of document. Reference numbers for other documents that have been assigned or released. For example, there may be a deed that has to get amended. On the amending deed, there would be a reference number to the recording number for the first deed that was recorded. Or if there, for example, with the power of attorney document, if it was recorded, the revocation document, when it's recorded, there should be a reference number for the original recording number of the power of attorney that is now being revoked. There needs to be a good legal description. Sometimes these are quite lengthy. Sometimes they are very abbreviated. I don't know that there's been anything, I don't remember having seen any cases that talk about using a very abbreviated legal description if that's all that's available. I often see the assessor's website, when you look at a property, you can find a legal description, and I often see that on deeds. That's usually not acceptable, and I have also seen that those sometimes are quite or maybe minimally incorrect, but enough incorrectness that it can cause a problem. You have to have the tax parcel number for the real estate that you're dealing with. There are some exclusions in documents that are recorded. They cannot include social security numbers for anyone. The date of birth that's identified with a particular person cannot be included. And the maiden name of a person's parent cannot be included if it can identify that person particularly with someone identified in the document. There's an acknowledgement requirement. Basically, a notary public is required to sign and attach their seal to the document in order for it to be recorded. And then there's a recording fee that has to be paid as well. And that will vary depending upon the type of document and the number of pages. A few years ago, there was a list of various types of documents, and it seemed like every one of them had a different recording fee. That has become a little bit more standardized, and it should be pretty similar from county to county. If the first page of the document to be recorded doesn't have the required information, such as the parties, tax parcel number, legal description, then a cover sheet is required, and it provides all that information, maybe in at least even the legal description may be in a very abbreviated form, but the cover sheet would then refer to a subsequent page of the document that is attached to it that sets forth the full legal description. In Washington, we have a real estate excise tax that on the transfer of real estate. And it's a percentage that's based on the value that's given in exchange for the transfer. And the state rate is anywhere from 1.1% of the consideration, what's being given or paid in exchange for the transfer, up to a maximum rate of 3%. Again, that depends upon the value of the property. So for example, on the first $500,000 of value that's given, it would be 1.1% of that amount. Local jurisdictions, cities, counties, etc., can impose tax as well. It generally ranges from 0 up to 0.5%. There are some exceptions. There are some that I've seen that are 0.75%. I've even seen San Juan County has 2%. And there may be limitations on what they can use that for. But that's generally the imposition of the real estate excise tax. There are a number of exemptions or exclusions from the real estate excise tax. Things like a gift. If a gift is made, there's no consideration. There's nothing given in exchange for that gift. In that case, there is no excise tax, but the exemption has to be claimed. Same thing is true when property passes under a will, in a probate, or in intestate or non-will administration of an estate, again, typically there is no consideration given for it, whether it's cash, an exchange of property, maybe assuming the debt. If there's debt on the property, there might be an assumption of debt. If there is an assumption of debt, so the granting party does not, no longer has to pay that debt, but the grantee party, the party receiving the property, does. Now we have consideration, and there will be real estate excise tax based on the amount of consideration given. Transfers that are made to and from revocable or irrevocable trusts are also subject to an exemption. Clearing or exiting title. This one may not be so clear. Good example is daughter wants to buy a piece of property, or son, but can't get the financing on their own. So mom and dad sign, and they're going to sign the loan along with son or daughter, but the lender wants to make sure that they've got an interest. So son or daughter may also grant mom and dad an interest in the property, but mom and dad really don't have an interest in the property other than it's treated as security, because they're likely to be on the hook to the lender if their son or daughter doesn't make those payments. Now, son or daughter then at some point maybe gets to refinance the property, and now they're in a position to be able to do that without the assistance of mom and dad, or the loan that mom and dad signed, they've now been paid off. So mom and dad are going to exit title to the property, and all they do is they quit claim their interest, but they're not, the only reason they got on the property, on the title to the property, was to help with the financing. So now if they got nothing in return, and if son or daughter was making all the payments on the loan, they can exit title to the property by a quitclaim deed and no real estate excise tax. A lot of people will, in forming a corporation or limited liability company, will contribute real estate to that. There are federal tax provisions that indicate that when you do that in exchange for an interest in the corporation or the limited liability company, you don't have any gain or loss, which you might otherwise have if you were transferring the property to someone else. Because of that, there is also an exemption under Washington law for a contribution of real estate to the corporation or the limited liability company in exchange for that ownership interest. If the corporation or limited liability company at some point then turns around and distributes the property to a shareholder or shareholders, or to members of the limited liability company, there's also an exemption available for that. The real estate excise tax affidavit is something that it gets submitted along with the conveyance document, whether it's a deed, typically a deed, but there would be other documents as well that could be used to convey title. The real estate excise tax affidavit, it's required for most transactions. You think of the deed, that's one definitely. They can get submitted to the same place, like the auditor's office, although the tax has to get, if there is tax, or if there is no estate tax, real estate excise tax, there is a transaction fee that gets paid normally to the treasurer of the county. They process it before the auditor or the recorder, as applicable, will record the document. There are some transactions that do not require submission of a real estate excise tax affidavit. For example, mortgages and deeds of trust, where you're granting a security interest, and that's what those two documents are. They're granting security interest in the real estate for the loan. So there is no real estate excise tax affidavit required. A fairly recent development, about 7 years ago now, transfer on death deeds. It's a way of providing for a non-will transfer of a piece of real estate upon the owner's death. When they record the transfer on death deed, there's no real estate excise tax affidavit required because there has been no transfer. A transfer on death deed is revocable. And so it's not until the grantor of that deed dies that a real estate excise tax affidavit has to be prepared. And when it's prepared, it is signed by the grantee or the recipient of that property. So that concludes my presentation for today. Would like to let you know that if you have any questions, you can give us a call, 425-776-4100. Next week, our litigation group will be presenting, and their topic is going to be friendly, quiet title actions. So I thank you for tuning in today, and have a great day.